Oh, so.
Calm down. Please calm down. I am in court. Of course, I'm definitely not carrying anyone in court. They are alive, they are well. Our detractors will not be. But I want to tell you, please don't destroy business. Don't lose lives. I am safe. I am sound. And I will not be cowed.
We may get representation in the forum for the defense. For the respondents.
Alongside who and who?
Alongside Ms. Wangui and Mr. Kamau for the states.
Good afternoon, Your Honor.
Good afternoon.
My name is Stephen Alonzo Musyoka, Senior Counsel. Appearing together with the colleagues whose names are read, starting with Honorable Eugene Romalo, Honorable Jerry Maina,
Present, Your Honor.
Counsel Kibe Ungai,
Present, Your Honor.
Counsel, the list is here. Yes, thank you. Counsel Elijah Ireri,
Present.
Kindly repeat. I'll repeat. Counsel Eugene Wamalwa,
Present.
Of Chief Inspector Desterio. Today, 8th of July, 2025. Supported, Your Honor, by an affidavit by Chief Inspector Desterio. The affidavit is deponed on an even date, 8th of July 2025. You know, the essence of the application is to request a limitation of the rights to liberty for a period of over 24 hours. And specifically, they are requesting for 14 days. 14 days at Mudaiga Police Station to allow investigations, Your Honor, into matters of collection and provision of property for commission of terrorist acts. Your Honor, and charge of conspiracy to commit a terrorist act contrary to Section 23 of FOTA. Your Honor, the grounds upon which this request is made is that the first respondent, who is a current member of Parliament for Manyatta constituency in Mp County, you need to sit. The first respondent is a current. Your Honor,
There's a small oversight on our part before we commence. Your Honor, these are applications that my learned colleague is trying to process. Is an application that we saw 10 minutes ago. And obviously, we have not been able to respond to this application. But given the nature of criminal proceedings, the defense will be satisfied with cross-examining Chief Inspector Desterio Omukaga on the content of this affidavit, and we propose it should be only after that cross-examination has taken place that the prosecution should then present its application.
Indeed.
you want to do cross-examination?
Yes, we want to do cross-examination.
Yes, indeed. And for that purpose, Counsel Reri will lead in that cross-examination. We are obviously vehemently in the position of this motion. So please, Counsel Reri lead us in this, and as Counsel Kibia said, only then can the prosecution prosecute the application.
Your Honor, that is just a minute. Proceed with the submission. Yes, Your Honor, I'm also opposed to that application to cross-examine Chief Inspector, Your Honor, the Chief Inspector who is the IO in this matter. And the reason is on legal basis. The law provides, Your Honor, that whenever any party desires to cross-examine anybody who has sworn an affidavit, then they need to do an application in writing. The said application in writing should highlight the reasons as to why that application may be allowed by the court. You know, we have a myriad of authorities to the effect that cross-examination of a deponent is not a matter of rights to any party, but cross-examination, Your Honor, of deponent is an application that should be done formally, supported with the grounds, Your Honor, And these grounds have been specified, Your Honor, by various authorities before a court binding to this court, including the High Court. And as, Your Honor, we respond to that application, which you are saying is not a right, and equally the defense counsel cannot say how they are going to have him cross-examined before the court makes a ruling on the same issue. So this is my objection. One, there is no written application, there is no notice issued for cross-examination, Your Honor, to the chief inspector who has deponed the affidavit. Secondly, there is no any written application to request for cross-examination. And thirdly, there is no hearing set for the application to argue as to the propriety of that application and whether the circumstances are right for them to be allowed to cross-examine. Your Honor, I wish to submit authorities.
You say there is no right to cross-examine.
There's no right to cross-examination.
There is no written application and
Your Honor, and there are no grounds that have been set in that application after hearing date has been set to raise or to give the reasons why the IO should be cross-examined. Your Honor, this is a matter that has been decided in the High Court at Mombasa in a constitutional petition number 8 of 2024 in matter of David Abe versus Inspector General of National Police Service, Ministry of Interior and National Coordination,
repeat the citation.
number 8 of 2024. David Abe, and Abe is A-B-B-E-Y, versus IG of Police as the first respondent, Ministry of Interior as the second respondent, and the Director of Public Prosecution as the third respondent, Your Honor. Your Honor, the ruling of the court was that the grounds that are supposed to be given for the cross-examination had not been given, and therefore the court declined to allow such an application, Your Honor, and I also served the court with a copy of the same order declining this kind of an application, Your Honor. Your Honor, in another matter, in the Land and Environment Court, civil suit number 157 of 2015,
Civil ELC.
ELC
ELC number
157 of 2015, in the matter of Papinda Kaur, P-A-P-I-N-D-E-R, P-A-P-I-N-D-E-R, Kaur is K-A-U-R at Y, A-T-W-A-L at Y,
80.
A-T-W-A-L,
Yes.
versus Habans, H-A-R-B-A-N-S, Amrit, A-M-R-I-T, and Kamar Parkash, K-A-M-A-L-P-A-K-A-S-H. Your Honor, a similar application now based on the civil procedure rules, order number 19. You know, you are told that the lights are defective. So, Your Honor, in this matter, based on Order 19, Rule 2.1 of the Civil Procedure, which I practiced a few years before joining the Criminal Procedure Code team, Your Honor stated that that application must be made in writing, and the decision was made that the grounds were not sufficient. You cannot just make that application without laying the basis. And Your Honor, the court declined to give the said application in the said ruling. That is Justice Mutungi, sitting at Milimani Law Courts. Your Honor, the said authority is equally supplied to the defense and a copy supplied to the court. Your Honor, in an anti-corruption matter, similarly, in the matter of Dr. Evans Kidero, who was the first petitioner, and 10 other petitioners, no 11, Your Honor, versus the Chief Magistrate of Milimani Law Courts, Ethic and Anti-Corruption Commission, DPP, and the DCI named respondents, versus the Chief Magistrate of Milimani Law Courts, Ethics and Anti-Corruption Commission, DPP, and the DCI. The counsel in this matter intended, Your Honor, to cross-examine and I. And at paragraph 37 of the said judgment ruling, Your Honor, all the way to paragraph 60, the court gave an analysis as to why the cross-examination of a deponent is not a right and can only be given in limited situations, Your Honor, that are discussed therein. Your Honor, I wish to serve the said authority to the defense and the court for that purpose. Your Honor, and a myriad of other authorities, Your Honor, that I have here. So what we are saying is that that order has been a trend that is just taken lightly. Anyone who wants to cross-examine an IO will just come, and maybe we get sometimes reckless and fail to consult the law. But the law is as is. That prayer cannot be granted orally. If they intend, Your Honor, to have another date set for cross-examination, we need to be served with an application with a legal basis so that we may respond, Your Honor. I have other sets of 5 authorities, Your Honor, that I will supply should they file that application to cross-examine the document. Thank you.
Your Honor, before I give the floor to counsel, it is important for Your Honor to note that none of those authorities have anything to do with the person charged under the Prevention of Terrorism Act. And also further note, Your Honor, that it's like an ambush. We are dealing with a member of parliament. If you allow me to make this general statement, member for Manyatta, the country is at a crossroads. The people of Manyatta and the Embu, not just to say the whole country, are watching clearly this political persecution. So it cannot be any other thing. We cannot call it by any other name other than this administration has chosen to carry out political persecution of its opponents. And so we want to urge Your Honor to be able to dispense with that written requirement in view of the urgency and the gravity of the matter before you this evening. I will ask Counsel Ndegwa Njiru to add to what I've just said.
Your Honor, Zero.
It's my humble belief, Your Honor, that we are faced with a criminal trial and not a civil one. And that where we are faced with a civil trial, the law applicable therefore is Cap 75. Of great relevance is the title to that act, which provides it's an act of parliament to make provisions for the procedure to be followed in criminal cases.
Yes.
Additionally, Section 3, which provides that all offenses under the Penal Code shall be inquired into, tried, and otherwise dealt with in accordance to the code. Therefore, the authorities that have been cited to you can be distinguished that they were brought or the decisions were made under Order 19, Rule 2 in a civil proceeding. When looking at the two codes, one would wish to address his or her mind to the standard of proof and the reason why we have those two sets of laws. If you were to look at the applicability of Order 19, Rule 2, the standard applicable is that of balance of probability. And therefore the judge or the magistrate has the liberty of placing the issues under a weighing scale and juggle the balls. In these proceedings, Your Honor, we are looking at a different standard of proof, beyond reasonable doubt. And that's why the Parliament deliberately created those two different codes. As I cede the floor, you'll note that this application has not been initiated under the Civil Procedure Code. And there are no rules, again, providing the manner in which an application such as this one ought to be commenced. At least I have not seen any rule emanating from Parliament. This has been as a result of judicial craft, or the DPP's craft, or matters of practice. That is why, therefore, Your Honor, looking at the gravity of the issues and the rights that will be compromised in the absence of cross-examination, the court will be invited to disregard the rules under Rule 19, Order 19, Rule 2, and look at the right that is about to be curtailed. Having been served 5 minutes before you took your seat, then the DPP proposes that we ought to move you with a formal application or a notice of intention to cross-examine, which has not been provided for by the rules or the code, would only be one who is not candid with the truth. We urge you to grant that application. It's the only way the veracity of the affidavit herein can be put to test. The deponent of this affidavit cannot just come and make allegations and then allege that a right to cross-examination does not exist. That right does exist in accordance with Article 50, the right to a fair trial. And suffice to note that Article 50 is one of the non-derogable rights. Therefore, it cannot be waived at the whims, wishes, and aspiration of the ODPP. Otherwise, Your Honor, to say that this is a question of mere discretion
would be to curtail the rights under Article 49 of the Constitution. Article 49, 1 of the Constitution, by allowing detentions for a period of 14 days.
Just come up again. Is it 6
Is it 30 days or 14?
It's written,
Yeah,
it's written for 13, but asking for 14.
some place it's saying 14, some places 30.
In the affidavit, it's 30.
In the affidavit it's
So
30.
14.
That's why it's causing confusion.
The application.
Yes.
14.
Precisely. Your Honor, as you can see, the application, the body of the application order 2, it is seeking 14 days, but in paragraph 11, the deponent is seeking 30 days. Part of the reason, actually, that should justify that cross-examination. But coming back to the 3 points that we wish to make on this application, the application basically seeks the derogation of the right to liberty secured under Article 49 of the Constitution. Your Honor will note that the starting point is that these are criminal proceedings. In criminal proceedings, and you can look at the Criminal Procedure Code, the trial is always conducted viva voce. Except in a few instances that are specifically stipulated by law. And in this case, which we shall go back to in point 2, is section 36A of the Criminal Procedure Code, where the prosecution is directly required to file an affidavit, but we shall be coming to that. There's an obvious reason why the trial in a criminal case must be conducted orally. One, I am not aware of any police station in the Republic of Kenya where accused persons are given computer services and all these other typing services for them to be able to react.
Mr. Kongo, just one observation from what has been submitted by my learned seniors. Your Honor, it's only in this country where the so-called terrorists come out in large numbers when the youth of this republic are exercising their constitutional rights under Article 37. Your Honor, we've had other groups come out to demonstrate before in this country. Even us, the LSK, sometimes we come out and we demonstrate. Your Honor, the doctors are always on strike. They are always on the road. Your Honor, even our learned senior, His Excellency, Mr. Kalonzo Musyoka,
I'm an expert.
is an expert in demonstration. And Raila Odinga, the list goes on. But in those instances, Your Honor, we never had this kind of charges where the demonstrators were brought to this specific court and charged with the offenses of terrorism. So, Your Honor, what I'm saying is that this goes out to show you the mischief that is behind these charges. And I pray that, Your Honor, this court should not entertain that kind of mischief that is politically motivated. Your Honor, there are other charges that the accused persons can be charged in other courts other than this. So, Your Honor, we pray that as you retire to write the ruling, you will look at what we've submitted and clearly see that there is some sort of malice on the part of the state. That's all there.